Okay, this I believe is cause 2021-0D00467, the state of Texas versus Ariel Gustavo de la Luz, present in court with his attorney, Mr. Morales, and the state's attorney, Ms. Espinosa. And Mr., is that your true and correct name, Ariel Gustavo de la Luz?
Yes, sir.
And your date of birth, 2/26/2003.
Yes, sir.
All right. And now, Mr. Morales, I don't know we could do this hearing in person, but we can also do it by Zoom. If you waive the in-person plea, do you and Mr. De La Luz waive this in-person hearing?
We'll waive the in-person hearing, Judge.
Do you agree with your attorney there, Mr. De La Luz? You want to do this by Zoom today?
Yes, sir.
Okay, then we will. All right. Then if you would state the plea agreement on the record, Ms. Espinosa.
Yes, Your Honor, it's 1244B, 2 years deferred.
All right. And is that your understanding of the plea agreement, Mr. Morales?
That is my understanding as well, Judge.
And is that your understanding of the plea agreement, Mr. De La Luz?
Is the probation right?
Yes, it's 2 years probation deferred under, what did you say, 1244, what?
B, Your Honor, which
B.
is a misdemeanor.
Which means it's being prosecuted as, being punished as a misdemeanor, not as a felony. Is that your understanding of the plea agreement, sir?
Yes, sir.
Okay. Now, you understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it? Should I choose to be harsher than that, you can withdraw your plea and we could proceed to a trial on this matter at a later date. But if I follow the plea agreement, it is final. You cannot withdraw your plea. You cannot appeal this case without my consent. You would begin serving this probation immediately. Do you understand that?
Yes, sir.
Okay. Now we have in front of us some documents marked State's Exhibit 1. The guilty plea and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, sir.
Did you read them before you signed them?
Yes, sir.
Did you understand what you were reading and signing?
Yes, sir.
Did your attorney further explain to you the meaning of the documents?
Yes, sir.
Do you have any question about their meaning?
No, sir.
So that there's never any question, let me briefly explain to you what they mean. Primarily two things. First, you're coming into court telling me through a judicial confession, yes, Judge, I did commit this this misdemeanor offense as it's being punished. And secondly, you're telling me that you understand that you're giving up some valuable rights here today. The most important of those rights is your right to a trial by jury, not only upon the issue of guilt, not guilt, but also upon the issue of any potential punishment. Do you fully understand that?
Yes, sir.
Understanding that, then how do you plead to this charge, guilty or not guilty?
The paper said guilty.
Yes, but what about you? I mean, are you pleading?
Yes.
You're pleading guilty?
Yes, sir.
Okay. Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Did anybody force you or threaten you, coerce you, or in any way make you plead guilty?
No.
No? Okay. Did anybody promise you anything or persuade you in such a manner you felt you had to plead guilty other than the plea agreement stated on the record in open court here this afternoon?
No, sir.
Okay. Now you understand the potential punishment here is from 1 day to 1 year in the county jail. Fine not to exceed $4,000. But instead of putting you in jail, I can place you on probation for any number of years, not to exceed 2. And you understand I have to sentence you somewhere within those general guidelines.
Right.
Okay. Now, are you a U.S. citizen?
Yes, sir.
And how old are you now, sir?
20.
20?
Yes,
How
sir.
far did you go in school?
Freshman.
Okay. All right. You're able to read and write the English language?
Yes, sir.
Have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
Yes, sir.
What was the problem? or is the problem?
It was depression, anger issues, stuff like that.
Are you presently under any medications for those?
Just the mood,
Mood stabilizers? Okay. Are they helping you?
not at all, sir.
Okay. Are you telling me though that are you telling me today that you are mentally competent? You understand everything that's going on here today?
Yes, sir.
Okay. And counsel, you've had time to go over the facts, circumstances of the case, the legal aspects of the case, and had time to evaluate your client's mental status.
I have, Judge.
Based on all that, you're representing me that you believe he is mentally competent to enter this plea.
I believe he's mentally competent to enter the plea, Judge.
All right. Then based on your representations, Mr. Morales, and your representations, Mr. De La Luz, and the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter the plea. State may summarize the evidence.
Yes, Your Honor, had the state proceeded to trial in this case, the state would have proven beyond a reasonable doubt each and every element in the offense of unauthorized use of. Sorry, Judge, let me make sure I know what the offense was. Unauthorized use of a vehicle.
Yes.
As alleged in the indictment, the state moves to introduce states exhibits 1 through 2, which are the plea papers and the 3914 disclosure form.
No objection to the introduction, Judge.
All right. Well, based on the evidence, the court finds the evidence is sufficient to find the defendant guilty and under 1244B, and I so find. I'm not finding you guilty. Pardon me. Because this is a deferred plea. What that means is I'm going to wait until some later date to finally decide this case. And that'll be based on your conduct. If you do well on probation, whether it takes 2 years or any time less than that, if you successfully complete it, the case against you is dismissed with no finding of guilt. And hopefully that's of some advantage to you in the future in getting new jobs and things like that and opportunities. That's the good way for it to end. The bad way is if you don't do what you're supposed to do, if you went out and committed other offenses, or just stopped reporting, they could bring you back before me. And if I found that you had violated your probation, I could revoke that and sentence you up to 1 year in the county jail. You understand that?
Yes, sir.
Now, and based on that, you still want me to grant your motion for deferred adjudication.
What does that mean?
That means that I'm not finding you guilty today, as I just explained. That it's not a finding of guilt. We'll wait until the end of your probation to see how you do. And if you do well, then it's dismissed without a finding of guilt. Okay?
So,
All right. Now, all right, let me see then. One other thing. Let me go over this. All right. Let's see. Now, are you married? Do you have children? Do you live at home with someone else, with your parents? What's your status there?
currently, I'm supposed to be living with my mom, but yeah, yes, I do have a girlfriend and a son.
You got a young boy?
Yes, sir.
How old is he?
5 months.
And let's see. Have you had a chance to see him yet?
I saw him like the first 2 weeks he was born, but I haven't seen him yet.
Since? Well, and hopefully you want to be involved in his life. So I'm happy you want to be involved in his life. But you're gonna go back live with your mother when you get out?
Hopefully, yes, sir.
Okay. And then what type of work have you done?
I do construction.
Okay. Do you think when you get out you'll have a job available?
Within the first week, yes, I should.
Yeah, there's plenty of work to do. So hopefully, have you got some people that you've worked a while with, a company or? Okay. Well, then I'm going to follow the recommendation, 2 years deferred, and good luck to you, sir.
Thank you.
Thank you. All right.
Judge, I hope the court would consider placing Mr. De La Luz, at least evaluating him for the mental health caseload. I think that might be useful, Judge.
All right, well, we'll do that.
Your Honor, there are also some misdemeanors associated with the case, and he is to be pleading to 3, and 1 is going to be dismissed.
I did get that email as well, Evelyn Wood, and I told him we're gonna sort those out.
Okay.
And so there's some misdemeanors still pending.
Yes, Your Honor.
So there's going to be a plea of guilty to 2 misdemeanors,
3, Your Honor.
3, and then a dismissal of 1.
Yes.
Are these going to be like the time served or something?
I don't know what option the defendant has chosen, but yes, either run concurrent, undeferred, or time served.
Okay. All right. Well, as soon as you get those cases resolved, they'll let you out of jail. You can get back home, take care of your mom, start getting involved in your son's life, and get back to work. So good luck to you there, Mr. De La Luz.
Thank you.
Thank you. All right. Let's talk next to Mr. Flick.
Courtroom sync. Just not 1 second.
We have all the paperwork on that one.
Go ahead, Jenny.
Yes, Judge, we do.
Oh, very good. And then, Mr. Avalar, are you there now?
Yes, Your Honor, I am, Judge, whenever you're ready.
Okay, well, I was going to do Mr. Flick, and then we'll come back and do
Okay.
Mr. Montoya, and we'll finish up. We've got all the paperwork on that one too now?
We do, Your Honor. Yes, sir.
Okay, good.
Thank you, Judge.
Okay. I just know, Miss Pettis?
Good afternoon, Your Honor. How are you?
I'm fine. You had your hand raised. Did you need something?
Oh, I'm sorry, Your Honor. No, I did not. Sorry about that.
All right. Well, I've called on you and you didn't really need your hand raised.
No,
Okay.
no.
Okay, got it. Thank you. Okay, let's proceed on then with Mr. Flick. All right, this is, I believe, cause 2020-0D03609, the state of Texas versus Philip Jesus Flick. Is that your true and correct name, sir?
Yes, sir.
And your date of birth, 6/8 of 1988?
Yes, sir.
And you recognize your attorney there, Mr. Morales?
Yes, sir.
And you recognize your client, Mr. Flick?
I do, Judge.
Okay, again, we could do these hearings in person or we can do them by Zoom. If you wish to do them in person, we can do that, but you can waive that. And if you waive it, we will proceed today. Do you waive the in-person hearing, Mr. Morales?
Judge, we'll waive the in-person hearing and proceed with Zoom.
And Mr. Flick, do you agree with your attorney to waive the in-person hearing and proceed via Zoom? I'm sorry, I couldn't hear you.
Yes, Your Honor.
Okay, thank you so much. All right. Then, if you would state, Ms. Espinosa, the plea agreement.
Yes, Your Honor, under the 2020 case, it's to revocation to 2 TDC, and I am dismissing 2022 0D02812.
So on the 2020, which is, 3609. That's going to be a plea of true, and that's going to be 2 TDC with credit for all time served. And then you are dismissing which case?
2022 0D02812.
28. Well. All right. Is that your understanding of the plea agreement, Mr. Morales?
It is my understanding as well, Judge.
Is that also your understanding of the plea agreement, Mr. Flick?
Yes, Your Honor.
Okay, now I don't have in front of me exactly how many days you have credit, but it would go back all the way to the date when you were first arrested in that 2020 case. In other words, every day you spent in jail, back from the date of the arrest until today would count towards credit. You understand?
Yes, sir.
Now, if you were out on bond at certain points, those don't count. But the time that you actually served in jail, that does count. Okay? Thank you. All right. Now, we have in front of us some documents marked States Exhibits 1, 2, and 3, the stipulation and waiver forms in this case. They bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you read them before you signed them?
Yes, Your Honor.
Did you understand what you were reading and signing?
Yes, Your Honor.
Did your attorney further explain to you the meaning of the document
Yes, sir, Your Honor.
or documents? Did you have any question about their meaning?
No, Your Honor.
So if there's never any question, let me briefly explain to you what they mean. A stipulation is merely an agreement between yourself, your attorney, and the state's attorney that certain facts are true, such as you were on probation and there were certain terms and conditions of that probation, and that you didn't follow all of those terms and conditions of your probation. And then they lay it out specifically which ones you did not. And then the waiver form is telling me that you are giving up a fully contested hearing before me, where the state would have to prove to me by preponderance of the evidence that you had violated that probation. Do you understand all of that?
Yes, sir, Your Honor.
Understanding that, then how do you plead to this motion? Is it to adjudicate or revoke? Let me look. On the plea, it was okay, straight probation. So the motion to revoke. How do you plead, true or not true?
Your Honor.
Are you entering your plea of true freely and voluntarily?
Yes, Your Honor.
Did anybody force you, threaten you, coerce you, or in any way make you plead true?
No, Your Honor.
Anybody promise you anything or persuade you in such a manner you felt you had to plead true, other than the plea agreement stated on the record in open court here this afternoon?
No, sir, Your Honor.
Now, you understand the potential punishment for this offense. It would be not less than 2 years, nor more than 10 years in prison, a fine not to exceed $10,000. You understand I have to sentence you somewhere within those general guidelines.
Yes, sir, Your Honor.
Now, you are a U.S. citizen,
Yes, sir, Your Honor.
and how old are you?
34,
And how far did you go in school?
junior in high school, Your Honor.
And you can read and write the English language?
Yes, sir, Your Honor.
And have you ever been under the care of a psychiatrist or psychologist for mental health, mental illness issues?
No, sir, Your Honor.
Suffered any serious head injuries?
No, sir, Your Honor.
Are you presently under any medications for mental health or mental illness issues?
No, sir, Your Honor.
And you're telling me you are mentally competent, you understand everything that's going on here this afternoon?
Yes, sir, Your Honor.
Okay. Then, counsel, you've had time to go over the facts and circumstances of this case, the legal aspects of the case, and had time to evaluate your client's mental status.
I have, Judge.
Based on all that, are you representing to me that you believe he is mentally competent to enter this plea?
I believe he's mentally competent to enter the plea, Judge.
All right. And based on your representation, Mr. Morales, your representation, Mr. Flick, the court's observations of you in court, both here today and prior occasions, I find that you're competent to enter the plea. State may summarize the evidence.
Yes, Your Honor, had the state proceeded to a revocation hearing in this case, the state would have proven beyond the preponderance of the evidence that on February 4th, 2021, defendant pled guilty to the offense of assault of a family or household member, impede breath or circulation, and assault of a pregnant person, and sentenced to 10 years probation. Thereafter, during the months of May 4th, 2021 and July 2021, the defendant failed to report to the El Paso Community Supervision and Corrections Department, failed to pay supervision fees, failed to pay El Paso Crime Stoppers program, failed to abide by the bill of costs, failed to complete the TAP courses, failed to participate in BIP, and failed to donate to El Pasoans fighting hunger. The state moves to introduce States Exhibits 1 through 2, which are the stipulations and waivers and the waiver of appeal.
No objection to their introduction, Judge.
Received. Based on the evidence before the court finds the evidence if find the allegations true, and I so find them true, I revoke the defendant's probation and I'm ready to proceed upon the issue of punishment. Now, when you get out of prison, Mr. Flick, what is your plan? I know at one point you were from Amarillo. Were you intending to try to go back there, or what are your plans?
No, sir, your honor. I'm actually gonna stay in San Rosario.
Okay, so once you get out, you're going to come back,
Yes, sir.
back to San Eli, and do you have family there, or
I have my wife there and my kids.
okay, and you hope to reunite with them?
Yes, sir. I have been reunited with them since the case.
And when you get out, are you going to have you have any job prospects?
Yes, sir.
What kind of job?
Masonry. I'll be a mason tender.
Now, I don't know if you ever got any, I guess, family counseling. There are some that you can get in the jail or even in prison. It could be helpful because obviously you don't want to have something like this happen again. You have to figure out how to deal with anger. Anger is a very common human emotion, and so you have to figure out a way to, when that occurs, when anger starts boiling up, how to back away from a situation. Don't escalate it. Usually the best advice is to just, when we start getting an argument with someone, arguments are inevitable, but when you start getting in an argument, just back away or just leave for a while, and they settle down. When people are calmer, then you can discuss things. The other thing that usually creates problems is if people are drinking or having alcohol, that makes it even worse. And so it's like, if you put I've usually used this example, if you get in an argument and you get angry and you're drinking, it's like putting gasoline on a fire. It can blow up. And so the less you can get involved in alcohol issues, probably the better. A little counseling in that area too, with AANA. I don't know if you do have any problems in that area. If you do, some of those could cause for you to draw your attention to it and make things better for you. And obviously, since you've been reunited with your wife and children, hopefully everything will work out much better. So I hope it goes well for you. Did you have anything else you wanted to add, sir?
No, sir.
Okay. Well, good luck to you, sir. And I will follow the recommendation. It will be the minimum sentence of 2 years to serve. And I'll give you credit for all the time that you have served. And good luck to you, sir.
Thank you very much, sir.
Thank you, Judge.
Thank you. All right. Now we can speak to Mr. Montoya. All right, Mr. Avalar. Now, which causes of action are we dealing with today?
Today's cause of action is 2017 0D00111. It's a theft of property, 1,500 to 20,000, Your Honor.
Was that a motion to adjudicate, motion to revoke?
It's a motion to adjudicate, Your Honor.
And he was on how much probation? On that one?
Don't know.
2 years, Your Honor.
2?
Yes,
Okay.
and it was running.
2 years
through
deferred. That's correct, Judge.
That was a 2 deferred. And so okay. And the rec on this one is going to be, how much was it? A certain amount of time in the state jail run concurrent with the others? Was it going to be 1 year state jail? Is that what it was going to be? Was that a state jail?
1 year state jail concurrently with the 3 TDC that he pled to last week, Your Honor.
Right. Is that the only one that was outstanding to
Correct.
do? Okay. So, Mr. Montoya,
Yes.
you've been listening to us here. This is, like you said, cause number 2017 0D00111. 0111. And again, your true and correct name is Isaiah Montoya,
Yes.
and date of birth 11/24 of 75.
Yes, Your Honor.
Okay, and we could have this hearing in person, or we could waive the in-person hearing and do it today via Zoom. Do you wish to waive the in-person hearing and proceed with the hearing by Zoom today?
Yes, Your Honor.
Okay, and Mr. Avalar, do you concur with that decision to waive his in-person hearing in front of the court?
I do, Your Honor.
So now, go ahead and state the plea agreement. We've already kind of discussed it. And Ms. Espinosa.
Yes, Your Honor, it's to 12 months state jail. And
Okay.
it is running concurrent with the other revocations. I don't know if you want me to list the clause numbers for the record.
If you wish, because I think I've already signed all of those judgments today, and now we'll add this one. And so hopefully then when all of that paperwork then finally gets to the jail, which should be either tomorrow or early next week, then they'll be ready to complete Mr. Montoya's case. So go ahead.
Yes, Your Honor, it's running concurrent with 2013-0D05106, 2013-0D06174, 2013-0D06175, and 2014-0D00575.
All right. And now is that your understanding of the plea agreement, Mr. Avalar?
Yes, sir.
And is it also your understanding of the plea agreement, Mr. Montoya?
Yes, Your Honor.
Now, you again understand the plea agreement is not absolutely binding upon me, but should I choose not to follow it, should I choose to be harsher than that, you can withdraw your plea. We could proceed to trial on the matter, well, actually to a motion to adjudicate hearing later. But if I follow the plea agreement, it's final. You can't withdraw your plea. You can't appeal the case without my consent. Again, you'd be transferred to the Texas Department of Corrections if they so choose at the earliest convenience to serve out whatever remains of that sentence. You understand that?
Yes, Your Honor.
Now we have in front of us some documents marked States Exhibits 1, 2, and 3. The stipulation and waiver forms in this case, they bear the signature of your attorney, the state's attorney, and what appears to be your signature. Did you in fact sign these documents?
Yes, Your Honor.
Did you again read these documents before you signed them?
Yes,
Did you understand what you were reading and signing?
absolutely.
And did your attorney further explain to you the meaning of the documents?
Yes, and you did a great job.
Appreciate your
Good.
document.
And so, do you have any question about their meaning?
I don't have a question about their meeting, but I do have a question because I would like to clarify whether or not we have actually been able to accumulate the total amount of days back time that I have. Because last week in court, I don't think that was solid. And
Oh, that's true. Let's see if they, from the clerk. So I know
Yes,
she's been
Judge.
work. Okay, and so have you, is it different numbers on each case or how did it work?
It's, yeah, there's different days on each case, Judge.
Yeah, because I mean, there's different arrest dates and all of that. The critical one for him, I believe, is the TDC one, right? Because that's the one because the others are all served out, they're pretty much done. They're 1 year and he's definitely got over a year on all of it. But how much time does he have on the one he's got to do the TDC? Is that what you want to know?
according to my calculations, Your Honor, it's approximately 750 days. I know that because in 2013, when I was originally arrested before I was put on probation in 2014, I did 11 months. And then in late 2021, when I was brought back from New Mexico, I did 6 months. And now I've been here 8 months. That's a total of 25 months, which is approximately 750 days, Your Honor.
Okay, so you think you got about 750? All right.
Yes.
Now, how many does it show that you were able to find so far in your initial search there from the clerk's department?
I have 726 days.
Okay, it's pretty
From 2013, he
Yes.
was detained May 7th, 2013.
Okay.
well, your
So-
estimation was pretty close.
Yes,
Mr.
I'm quite in
Montoya?
that position.
Well, when I tell you, when it's your days to serve, it's important to be accurate. So
Yeah, it was simple arithmetic, but I mean, I really did attempt to get the proper number, so I thank you, Assistant District Attorney, for that. Because it's
All right.
close enough, I think.
well, that was our court clerk. She did a very good job.
I'm sorry
You're
about
welcome.
that.
She worked on that, and so okay, there it is. We've got, and then probably counting today, that's another day, so maybe up to 727. So, and by the time they get ready for transfer, that's going to be 365. That's over 2 years. That's
Yeah.
right around 2 years, right?
Yes, Your Honor.
So there's only a year left maximum, and I don't think that they rarely make people serve out every day, particularly if they behave and do good things. So hopefully you'll be out soon.
Yes, Your Honor.
All right. So with that, did you have any other questions?
No, but once again, I have a statement and I thank you for everything. And I do have some amazing, awesome plans in the writing world coming up. And I would like to keep you abreast on those in the future, as best as my ability enables me to, and I want you to be proud.
Well, we're going to be looking forward to your success. And so certainly you can write the court anytime you wish.
Okay, I appreciate it.
All right. So now, let's see, no other questions? And okay, so then how do you plead to the motion to adjudicate true or not true?
True.
Okay. Are you entering your plea of true freely and voluntarily?
Yes,
Did anybody force you, threaten you, coerce you, or in any way make you plead true?
no,
Did anybody promise you anything or persuade you in such a manner that you felt you had to plead true, other than the plea agreement stated on the record in open court this afternoon?
no.
So you understand the potential punishment for that offense is 6 months to 2 years in the state jail, fine not to exceed $10,000. You understand I'm about to sentence you somewhere within those general guidelines.
Yes, Your Honor.
Well, based on our plea last week, you're a U.S. citizen. You certainly can read and write the English language very fluently. And you are still saying that you are competent to enter these pleas.
Yes, yes, Your Honor.
And nothing has changed since last week. Okay. And Mr. Avalar, nothing's changed here. He's still the same competent person you've been dealing with.
Yes, sir, very much so.
All right. Then based on your representation, Mr. Avalar, your representation, Mr. Montoya, the court's observations of you in court, both here today and many occasions, I find that you're competent to enter the plea. State may summarize the evidence.
Yes, Your Honor, had the state proceeded to a revocation hearing in this case, the state would have proven beyond the preponderance of the evidence that on or about March 11, 2022, the defendant pled guilty to the offense of theft of property more than or equal to $1,500, but less than $20,000, and sentenced to a term of 2 years deferred probation. Thereafter, between the months of June 2022 and July 2022, the defendant violated his probation by committing the offenses of possession of a controlled substance, burglary of vehicle, and where's the other one? I think there was another offense. Pursuant to the state's amended motion to adjudicate guilt, the state moves to introduce state's exhibits 1 through 2, which are the stipulations and waivers, and the trial court certification of the defendant's right to appeal.
Any objection?
No, sir, no objection.
Well, then if the court receives the documents, the court finds the evidence sufficient to, I guess, revoke the defendant's deferred adjudication and find him guilty in the original charge. And I do so find, and now I'm ready to proceed upon the issue of punishment. I think last week we talked pretty extensively about your hopes to continue writing, about getting engaged and looking forward to a really productive life as soon as you can return to El Paso, which hopefully won't be too long. And so with that, I will follow the plea agreement, 12 months in the state jail on this case. It runs concurrent with all of those cases, and you get full credit for all the time that you've served in that case. And good luck to you, sir.
Thank you, Your Honor. Blessings.
Well, bless you too, sir. Thank you.
Thank you, Judge. May I be?
Thanks. You may.
Thanks so much.
Let's see. The next case up would be would it be suing?
That's correct, Your Honor. Jerry Lee suing.
All right, let's look at this case.
This is a bond issue.
This is a bond issue, correct?
Mr. Suing and
Right. Oops, let's wait till he gets present. So we want to make sure he's there. All right, there's Mr. Suing. All right. Your name is Jerry Lee Suing or Jerry Lee, and it's Bob too, Suing, correct?
No, Jerry Lee Soon.
Okay. And your date of birth, 3/22 of 1993.
Yes, sir.
You recognize your attorney there, Mr. Solis? Maybe
Yeah.
raise your hand there. Okay, Mr. Solis, you recognize your client there, Mr. Suing.
I do, Your Honor.
Okay. And now Mr. Suing has been in jail for about 172 days. And what is the bond presently say?
There are several bonds, Your Honor. For purposes of this court, he's got a $30,000 cash or corporate surety bond on assault of peace officer. That's 3 counts. And then the burglary of a building at a $30,000 also cash or corporate surety. And then he's got other bonds on misdemeanor issues. But for this court, he's got those 2 bonds.
So a total of about $60,000 bond?
That's correct. And Mr. Suing was insisting on a bond hearing, although we have some issues with regard to where to stay here locally and that there is no place to stay. It's very similar to a situation we had last week with another defendant. So he has family, I think, in Alamogordo, Mr. Suing, if I'm not mistaken.
Yes.
And then there's another fellow that calls from out of state as well. But so that's a situation with Mr. Suing.
Okay, let's go over, I think we did go over some of the facts of the case at a judge's pretrial conference at the beginning of February. Let's see if we covered all of the information.
Mr. Solis, Judge, if I may, he does have a hold out of Maricopa.
So there's a hold from Arizona
That's correct.
for what?
I do not know, Judge. That's the only thing I show in Odyssey.
So even if we made the bond here, he's still, well, then they would just send him to Arizona, I guess.
I
You
know,
know what, you know what the
from-
charge is in Arizona, Ms. Espinosa?
Let me check real quick, Judge.
the information I have is that he was released from prison in Arizona. And I don't know if that was sort of a mandatory release like they do here, but it could be a parole issue. I'm guessing, however. He was on his way to Austin, Texas, is my understanding.
When these incidents occurred.
Right. He's a mental health consumer in other states, and so these incidents happened here.
Okay. Did you want to briefly go over the facts and circumstances of the case, Ms. Espinosa, viewed from the state standpoint?
Yes, Your Honor. Do you want me to review the burglary building?
Well, yes.
Right, because there's 2. There's the burglary building, and then there's the assault on
the
a
peace
peace officer, right? And so the assault occurs after when they're trying to arrest the defendant.
But
Uh,
both
but
offenses basically occur on the same day.
Yes, Your Honor, and the first incident is the burglary of building. This was on September 25th, 2022. The defendant entered Hookah King Smoke Shop on Gateway East. And at this point, it's just the clerk and the who is the complaining witness and the defendant. And he starts, I guess, talking to her. She says that he starts making sexual advances and telling her that he's thirsty. And then she said that he had come in before and they would occasionally flirt, but this time, and it's seen on video, Judge, that he goes behind the counter and he tries to grab at her. She says that he tried to grab at her private part. And then when she gets up to move, he sat down in the employee chair that she was sitting in. And he only left. He keeps following her around the counter, and he left when her male friends arrived. And one of the male friends actually is involved in an assault with the defendant later on.
Yeah. And then with the police are called in, and what happens there from the police viewpoint?
Right, the assault peace officer, Your Honor, give me 1 second. That's also on the same date. I have to open portal real quick. I don't have the facts. No, I do have them, but I just they're in my notes section. Give me 1 second. Okay, so it's the same date. This is 9 p.m. Police are dispatched to the La Quinta Inn on Gateway East. Regarding a shooting, the defendant was at the scene, but he was injured, so he was taken to the hospital. And through their investigation, they found out that he was involved in the burglary of building or the business and the assault that happened later. And when they went to the hospital to arrest him, he resisted, assaulted the officer by scratching his left forearm, as he was being pulled out of the unit at the station.
Now at the hotel or the motel?
No,
he-
Judge, this is at the hospital.
But I mean, yeah, but at first they go to the La Quinta, you said, right?
Yes.
So there are reports of a shooting, Your Honor, and when the officers respond to the shooting in the location, they locate Mr. Sewing, who's in the
Right.
vicinity of the La Quinta Inn.
Right,
And
but
so
he
they
was-
make
they
contact
said he
with.
was injured though.
Yeah,
Was he shot? Was he shot?
No, he fell and he fell on his knee. So
Okay.
the injury is unrelated to the shooting
Oh, okay, good.
and the injury is unrelated to the burglary of a building. But in questioning Mr. Sewing, there's the indication that he was involved in a burglary of a building or something.
Right,
And so he's transported to the hospital as a result of, he said he fell on his knee, but in the hospital, he's having an episode, a mental health issue. And so there's damage to the vehicle. There's a criminal mischief related to the patrol unit because, again, related to the alleged assault on the officer. It's really a glorified resisting arrest. Judge Paxson used to indicate years ago is normally the fallback charge when they overdo it a little bit on the defendant. And so the assault on the peace officer is as a result of the resisting arrest. The criminal mischief to the unit is as a result of the resisting arrest in response to a shooting that's unrelated to Mr. Sewing in any way. He just happens to be, I think he says he's looking for a friend or something. And so they question him. He tells the officer, hey, look, I've hurt my knee. Officer says, well, we can take it to the hospital. And that's where it starts.
Okay, what is his criminal history, Ms. Espinosa?
Yes, Your Honor. So he doesn't have anything here. He does have every arrests out of Phoenix, Arizona, or out of Arizona. But I just saw probation. I'm not sure if there's a prison sentence. 2013 false report to law enforcement and the possession of marijuana, but the false report was dismissed. 12 months on the possession. 2015 criminal trespass. It just says guilty, unknown sentence. 2016 false report to law enforcement, 12 months probation. 2017 criminal damage, endangerment, disorderly conduct. Looks like that was dismissed. And then in 2019, this might be where prison sentence stems from, it's a burglary, possession of weapon, narcotic, drug possession. And then in 2020, misconduct with weapons involved, and then disorderly conduct, both felonies. But according to the rap sheet, it looks like he was sentenced to 2 years probation. I'm not sure if he was later revoked.
Mrs. Espinosa, those are in Arizona?
Yeah.
Yes.
Okay, all right, thank you.
Well, you know, it's kind of it. They got a hold on him here. Is it is it an FFJ or what is it? Or just a hold?
Let me check, Judge, real quick. It's just a whole warrant. It's a warrant, Judge. Hold for Maricopa County warrant.
All right. All right.
Is that two?
Your position on the bond, Mr. Solis?
My position on the bond is that Mr. Sewing insisted on the bond hearing, but I'm aware of the limitations, given that there are no family roots, there are no real venues for him to reside here locally. And I know that there's a issue out of Arizona. I was aware of that issue with the hold out of Arizona. I thought it was a warrant. I didn't realize it was a detainer and a hold already, but I knew there was a warrant. Or I had a pretty good idea there was a warrant. Let me put it that way.
Okay, Miss Espinosa.
Well, Your Honor, and let me add that I have given a recommendation of 6 months state jail on the burglary of building.
That had to be very recent because I looked just a couple of days ago and there was no wreck.
I just put it up there today, Mr. Solis.
Oh,
I'm sorry,
Very
and I
good.
did email you, but I guess you haven't had a chance to.
No, that's very recent wreck. So it was just today. So that's a 6-month wreck on the burglary of vehicle. And then what are you gonna do? Dismiss the assault on peace officer if he pleads to the 6 months?
180 days, lesser included on the assault. And then on
Okay.
the assault of a peace officer. And then dismiss 2 of the misdemeanors, Your Honor. But essentially, it's 180 days, which I believe he's close to completing.
is it on the portal, Miss Espinosa?
Yes, it's on all of the case numbers.
All right, so then I'll look and then review with Mr. Sewing here before Monday.
All right. Well, given the real lack of anywhere to go in this community, where to stay, and some of the past criminal history, and yeah, I'm going to go ahead and deny the motion to revoke. And anyway, because there's a hold for him anyway, and so it wouldn't do any good to release him because they take him to Arizona, and then we might not ever get him back here for our case. I don't know how long they'd want him in Arizona. All right. So with that, thank you, Mr. Solis. Good luck to you, Mr. Sewing.
Thank you, sir. Thank you.
And,
May I excuse, Your Honor?
Yes. And so Mr. Solis will probably get together with you and go over this plea recommendation. All right, sir?
Thank you,
Okay.
Your Honor.
Thank you. Okay. All right. Let's see. Which one is yours, Miss Pettis?
Good afternoon, Your Honor. I have Mr. Jeremy Wayne Qualls. And I also had Mr. Daniel Solis, but a motion to dismiss has been tendered by.
Oh, that's right. I just signed that.
Yes, Your Honor.
Just now. 3.
Yeah, apparently it's an old possession charge, Judge. It had been pending since last year and he has been doing really well. He went to rehab and he pled on a DWI. And so the other ADA that was handling it agreed to dismiss it and it was still filed.
Okay, so that one is being dismissed. That was Ms. Pettis's case.
Yes, Your Honor.
So Well, that's better than a bond reduction.
Absolutely.
All right, well, better let is Mr. Solis there?
Yes, Your Honor, it's on route.
And I think I just signed that one this afternoon. Isn't that right, Ms. Nolasco?
Yes, Judge, it's signed and I also forward a
Yes.
copy to the jail.
Okay, well, they already have seen it. Okay, well, Mr. Solis, good afternoon. We were set for a bond hearing, but the news is even better than that for you, so I don't mind passing on good news. The state has dismissed this charge against you, and that I have signed that dismissal this afternoon. That will be going over to the jail. If there's nothing else holding you, then you will be released. And I guess you did very well in a drug program or something
Yes.
that you went. Did you learn some things there?
Yes, I did, Your Honor.
All right. Well, hopefully, how long have you been in jail?
4 months.
Well, hopefully, now when you get out, where are you going to go?
Going home, I think.
Okay, where home with
My mom.
your mom?
Yes, my mom.
Good. You got a job and
Yes, I got a job lined up at the refinery.
oh, they pay good money.
Yes, sir.
All right. Well, it sounds like you're going to get your life back together. Congratulations.
Appreciate you.
Thank you, sir.
All right, thank you.
Okay. Then let's go to the next one, which is Mr. Qualls, you said.
Yes, Your Honor. Jeremy Wayne Qualls.
Okay. Now, in this case with Mr. Qualls, the defendant has been in jail. Look here, some odd days. It's about 37 days. And what is the bond here, Ms. Perez?
Their bond is currently set at 50,000 cash, Your Honor.
$50,000 bond.
Yes, Your Honor.
All right. So, Ms. Espinosa, what are the alleged facts here?
Yes, Your Honor. This allegedly occurred February 8th of this year. Police were at 9:30 a.m. I'm sorry. Police were dispatched to the Family Dollar on 160 North Cotton regarding a subject with a weapon. And when they arrived, Your Honor, I guess they saw the defendant by the dumpsters in the back. They asked him to show his hands. He reached into his fanny pack and pulled out a large knife with a black blade. Said the complaining witness, who I believe works at the Family Dollar, said, maybe not, but he said that he saw the defendant digging through the dumpster, throwing cardboard out of the dumpster, making a mess. He told him to stop. The defendant got agitated and pulled out the knife, began swinging it at him. That's when the complaining witness ran inside the store and called police. Apparently, there is a recording of the incident. One of the witnesses said she recorded it on her phone and showed it to police.
All right. And do you have a criminal history on the defendant?
Nothing in El Paso, Judge. It looks like there was in 2021 an assault out of Portland, Oregon, but that was dismissed. In California, 2002, inflict corporal injury on a spouse,
2000 what?
2002. And the
Okay.
only thing it says is conviction probation. And then 2006, cruelty to child, possible injury or death. But that says, I can't tell, this is just what it says, Judge, 5 years probation, 6 years prison. So maybe it was suspended. And then 2022, battery, also out of California, just says probation.
What was that last year? 2000 what?
2022.
Okay. And so, Ms. Pettis, what do you know? Is the defendant, doesn't sound like he is from here. What do you know about him? Have you had a chance to talk to him?
Yes, I have, Your Honor. My understanding from the two conversations that I have had with my client is that he is from California, Eureka, California. However, he has been residing here for quite some time, is my understanding based on what he told me. He did graduate with his high school diploma, attended 2 years at College of the Redwoods in Eureka, California. He represented that he is an SSDI recipient. He has been receiving Social Security disability since approximately 2006. He receives approximately $1,600 per month. There is a 1622 on file, Your Honor, which was a diagnosis of anxiety disorder unspecified. He currently is on medication for that. My client reports that he also suffered a TBI as well. At one point when he was assaulted, he also is diabetic and was, prior to the alleged incident, had just been recently released from the hospital due to some hip issues that he was having, and he had been receiving therapy at a rehab center. With regards to any minor children, he does not have any. He did report that he has one adult daughter. With regards to available cash, based on, of course, the nature of the offense, I understand that he does not qualify for straight PR bond, and so does Mr. Qualls. He has approximately $750, Your Honor, that he could possibly use to go towards a reasonable split bond.
Where was he residing before this incident?
At the Gateway Motel, which is where that's generally where he rents a room on a month-to-month basis. So that is where he would be returning if the court allows him to be released, or he understands if the court does not feel that that is a stable place for him to reside, he is willing to reside at a homeless shelter.
Have you come up with a rec yet on this case, Ms. Espinosa?
No, Your Honor, I haven't.
What are you trying to check more into the criminal history and particularly California and see what that's all about?
Yes, there was that, and I just wanted to make sure we had made some contact with the complaining witness. But I guess I also wanted to know, and maybe this was already answered, but I'm not sure if there are any mental health issues that Mr. Qualls needs help with.
It sounded like there were, and probably you had the TBI she mentioned, and you mentioned she mentioned he was on some medications, and I'm assuming that the disability has to do primarily with mental, is it, or is it physical, or both?
So I did have, Your Honor, my social worker, Ms. Reese, did talk to Mr. Qualls before today's bond hearing. My understanding is that there is some mental health issues there. He has been referred to the EHN Restorative Justice Program to address his mental health issues, and also kind of to work with him with regards to linking him with services, benefits assistance, and housing. I've also requested that he sign a release so that we can go ahead and get his medical records to inquire with regards to the TBI. My understanding is that he was assaulted, which is where that TBI resulted from. But at this time, the only thing that we have been able to address with regards to potential mental health is the anxiety that he reported to the individual that evaluated him during the 1622, and that's what has been reported to be by Mr. Quails as well, and what was reported to our social worker, Ms. Reese.
Okay, I forgot to do one thing. This could be an in-person hearing unless, I would have to redo it, and have him brought down to the courthouse if he wants to do that, or are you willing to waive that physical hearing for this Zoom hearing?
Yes, Your Honor, that was explained to Mr. Qualls as well yesterday when I spoke to him.
Okay, so both of you had agreed to that. Good.
Yes, Your Honor.
All right.
I mean, I would like to see that he is on his medication and already has a for sure place to stay and appointments with EHN prior to being released. But also, are his intentions to stay in El Paso? It doesn't sound like he has a lot of ties here.
No, his intentions, he had been here in El Paso.
How
So
long-
his intentions, my understanding is that he came here due to the cost of living is what Mr. Qualls reported to me.
But so, Mr. Qualls, how long have you actually resided in El Paso?
For approximately 5 years total. I was here before. I went back and saw some family and visited, and I came back because of the low cost of housing. And the rent is low, which I established and was staying in. I could stay there all year long, so I have a definite place to go. And I also have a rehab help, like an assisted living where the nurse takes care of about 8 of us. So those are the 2 homes that I could immediately get into. And I enjoy El Paso because of the weather. My bones don't hurt. And most of my pain is from the 2002 skilled nursing facility injury that I hurt my lower back, L5S1 disc, and took care of the old people there. So my hip just got wore out. I think I need a new hip. Basically, that's what I do is Bible, and I pray. I'm a Pentecostal believer. I just take care of my ADL.
Okay. Well, what I'm going to do, this knife thing kind of bothers me, Miss Pettis. If it wasn't for that, it wouldn't be any problem at all. I just PR bonding, because it would have been just like going through a dumpster or something. I mean, or even, having problems there, but that does concern me. I do want to sit down and talk with you and Ms. Espinosa, maybe in person, about this. If we have time tomorrow, if not tomorrow, we can, probably not tomorrow's not a good day, but early next week, maybe by Wednesday, we can talk about the case and decide what you're going to do. Give us a better, what do you call it? Security plan. So it's more in writing as to what kind of stable environment he could be in.
Yes, Your Honor.
And then we'll see where we're going to go. And by then, Ms. Espinosa can also maybe get a little better clue as to what kind of criminal history he's got. Some of that California stuff is hard to figure out. Okay, thank you. But for today's purpose, I will deny it, but I will, look at it again. Without another forced hearing, I'll look at it again next week. Okay.
Yes, Your Honor. I guess I'll just go ahead and contact Ms. Espinosa, and then we'll agree as to when we will go pay you a visit with regards to this case.
Right.
Thank you very much. May I be excused?
You may.